South Korea's digital platform policy and AI ethics in virtual identity management. South Korea has positioned itself at the forefront of digital governance by establishing a regulatory framework that addresses the ethical and legal challenges of virtual identity management. Central to this framework are laws and policies that govern likeness rights, personal data, content moderation, and digital personality protection. Together, these elements form a cohesive policy environment that influences how digital humans, AI-powered identity agents, and virtual influencers are created and used on South Korean platforms. Likeness rights in South Korea are legally protected through an evolving combination of statutory amendments and judicial decisions. A defining moment came in the 2025 Plave libel case, where the court ruled that defamation aimed at digital avatars could be treated as a violation of the performer's personal rights. This established that avatars are extensions of real individuals and must be afforded legal protection. South Korea's 2022 amendment to the Unfair Competition Prevention Act further strengthened likeness rights by enabling individuals, both celebrities and non-celebrities, to take legal action against unauthorized commercial exploitation of their image or persona. Earlier decisions from the Seoul High Court, 2015, and Supreme Court, 2021, emphasized the need for specific contractual limits on the use of likeness, reinforcing that even consent must be time-bound and clearly defined. While not explicitly focused on likeness rights, the AI Basic Act, 2024, lays the groundwork for ethical handling of identity-related content, emphasizing transparency and accountability in AI-driven systems. The Personal Information Protection Act, PIPA, is South Korea's cornerstone legislation for managing biometric and identity-related data in virtual platforms. PIPA classifies biometric identifiers, including facial recognition data and behavioral traits, as sensitive personal information, subject to strict handling requirements. Organizations must obtain explicit consent for collection and usage and are required to minimize data use. Amendments to PIPA have bolstered the rights of individuals to challenge or refuse automated decision-making, a critical safeguard given the growing deployment of AI identity systems. A proposed 2025 amendment seeks to expand lawful uses of personal data for AI development while requiring strong risk mitigation practices and transparency in how data is processed. The Personal Information Protection Commission, PIPC, has also issued AI-specific guidelines that span the AI lifecycle, from privacy by design in development to rights assurance in deployment, encouraging pseudonymization during AI training and mandating clear user disclosures during AI operation. In terms of content governance, South Korea has enforced a structured and technology-integrated approach to moderation. The Korea Communications Standards Commission, KCSC, is the principal body overseeing online content standards, while the Information and Communications Network Act obligates platforms to mitigate harmful content and preserve user privacy. South Korea has gone further by criminalizing the creation, distribution, and even possession of non-consensual deepfake pornography. Penalties are severe, reflecting national concern over digital sexual abuse. AI systems are actively used to detect and suppress harmful content, particularly deepfakes and hate speech. Regulatory pressure has increased on platforms to apply these AI systems effectively, with fines and legal consequences for non-compliance. Alongside this, the PIPC ensures that content moderation practices involving personal data adhere to existing privacy protections under PIPA. Digital personalities, such as virtual humans and AI-generated personas, are safeguarded by both legal rulings and ethical mandates. The Plave Court decision marked a judicial breakthrough by recognizing that virtual avatars are directly tied to the personal dignity of the individuals who animate them. This jurisprudence is reinforced by amendments to the Unfair Competition Prevention Act and recent deepfake-related legislation that criminalizes malicious uses of digitally altered identities. Ethical governance is promoted through the National Guidelines for AI Ethics, 2020, which articulate 10 principles, including human dignity, accountability, and fairness, as voluntary but strongly encouraged standards. The Ministry of Science and ICT has collaborated with academia and industry to establish a broader ethical infrastructure, including the AI Ethics Framework Enhancement Project. This initiative produced AI ethics textbooks, checklists, and public forums, all designed to normalize ethical reflection in AI development. Legislative developments, including the AI Basic Act and the AI Protection Act, extend these ethical norms into binding requirements, mandating transparency, safety checks, and human oversight in AI deployment. The rise of AI-generated virtual identities has prompted broader ethical discourse in South Korea. Scholars and policymakers have highlighted concerns around consent and emotional manipulation, especially with technologies such as grief bots that simulate deceased individuals. Questions of authenticity and user deception also arise when virtual influencers do not disclose their artificial status. Further, expanded AI use in surveillance and public services raises alarms over privacy erosion and algorithmic bias. These concerns have prompted institutional responses, including updates to AI ethics guidelines and sustained civil society involvement. Over 120 organizations have advocated for rights-based AI regulation, underscoring the importance of public oversight and inclusivity in shaping digital identity policies. The AI Basic Act serves as South Korea's legal backbone for AI-driven identity systems. It adopts a risk-based approach, requiring high-impact systems to meet rigorous standards on transparency, data security, and ethical compliance. These requirements are highly relevant for developers of virtual influencers and identity agents, who must disclose AI involvement and maintain human oversight mechanisms. The Act intersects with PIPA, which ensures data privacy and limits the misuse of biometric identifiers. Institutions such as the National AI Committee and the AI Safety Research Center have been established to coordinate policy, manage AI risks, and promote secure system design. Together, these mechanisms reinforce a governance model where innovation must be harmonized with ethical standards and user protections. When compared globally, South Korea's regulatory stance is balanced and structured. It shares the European Union's emphasis on risk-based classification and ethical oversight, as seen in the EU's AI Act and GDPR. Unlike Japan, which relies on voluntary ethical guidelines, South Korea has codified many ethical principles into binding law. The United States continues to depend on sector-specific laws and voluntary compliance frameworks, making South Korea's model appear more centralized and comprehensive. In this way, South Korea has emerged as a middle ground between the EU's precautionary governance and the US's industry-led innovation, offering a framework that advances AI technology while embedding strong protections for virtual identity. Ultimately, South Korea's digital platform policies and AI ethics standards shape the creation and use of virtual identities through a tightly coordinated system of law, ethics, and institutional enforcement. By combining legislative rigor with ethical foresight, South Korea not only protects individual rights in digital environments but also provides a replicable model for managing the complex challenges of virtual identity in the AI age.